Hi, it's Wendy Hernandez, attorney and creator of Command the Courtroom. As you head into trial for your hearing, not only should you be worried about what it is that you're talking to your trial judge about, because your trial judge is the one who's going to be making decisions about your case and about your future finances and your future with your children, but you have to be worried about a court's involvement down the road. And hopefully, in your case, you're going to get a result that either you're really happy with or that you can at least live with. But if you find yourself getting a result after your trial with your trial judge and you're in a situation that you're not happy with the result, or it's not one that you can live with, or it's not in the best interest of your children, or you think that your trial judge abused his or her discretion, or the result was just plain wrong, then you may need to appeal those results. So what the appeals court is going to look at, one of the things, they're going to look at many things, but one of the things they're going to look at are the objections that you've made during your trial. And when you make objections during your trial, you're making a record, or you're preserving the record. That way, if you're objecting, when you go to the appeals court, you can say to the appeals court, I want you to look at these mistakes that the trial judge made. And the mistakes are when I asked for the trial judge to do X, Y, Z, and the trial judge didn't. Or when the other party asked for the trial judge to do something and the trial judge did. But if the Court of Appeals does not have your objection on record, meaning you saying in the courtroom, I object on these grounds, or you filing some sort of motion with your trial judge objecting to evidence and doing this before the trial, then the appeals court is not going to have anything to do. They're not going to have anything to look at. They're not going to know what objections that you're making to the trial judge's decision. And so in legal terms, that means that you have waived your objections, and you've not done a very good job of preserving the record. So, in a nutshell, when you present your trial, you're going to want to preserve the record in case you have to go to court in the future and have a higher court look at the record. This means objecting when you think the other side is trying to get evidence or witnesses in that shouldn't be let in, and also stating to the judge what your evidence would show if the judge would let it in, if the judge has made a decision not to let that evidence in. It also means, if it's appropriate in your jurisdiction, to file motions ahead of trial to have the judge rule on contested issues or contested evidence. And in the United States, anyway, this is called filing a motion in limine. So it's motion INLIMINE, for those of you that want to research that on the internet. So preserve your record. I hope you don't have to go to the Court of Appeals or an appeals court to look at your case once the trial judge makes a decision, but if you've preserved your record, you're going to increase your chances for success. So until next week, I want you to make sure and go to the YouTube channel and subscribe to Command the Courtroom. Also, like us on Facebook, head to commandthecourtroom.com to check out all of our videos and all the free resources I have there. But keep on trucking in the meantime, and remember to command the courtroom.